There's been a lot of talk lately about injunctions that have been issued against the Trump administration. But what exactly is an injunction? Let's talk about that. Hi, folks. Tony DeWitt again with another video on the law. Remember, I don't dispense legal advice here, and this is what we're talking about today. Today, I'm exploring the topic of injunctions in the context of the changes going on in Washington, D.C. I'm working from the case documents obtained on PACER, my own experience, and a sprinkling of case law. This is not meant to be political. I really don't care who wins in all of this as long as the rules are followed and justice is done. No one else should either. As a country, we spend way too much time cheering for winners and crying for losers, when what we really should be doing is being more interested in whether the courts are fulfilling their function and whether justice is actually done. Now, this video is going to be a little bit longer than some of my others because we need to get into some depth here. So if you can't watch it all at once, throw it in your watch later and watch it when you can, because this is important. So with that, let's start. Injunctions are a powerful tool used in the legal system to prevent harm or maintain the status quo. Let's dive into what injunctions are, why they're sought, and how courts decide whether to issue them. An injunction is a court order that requires a party to do or to refrain from doing specific acts. For example, an order that a state, Michigan or Missouri, can't ban all abortions by statute, and as a result, the ban cannot be enforced. That's an injunction essentially requiring that someone refrain from acting, or requiring the reinstatement of a person terminated from employment. That is an injunction requiring that they do something. Unlike damages, which offer monetary compensation, an injunction is about preventing harm or compelling specific conduct. Now, that doesn't mean that someone seeking damages can't also ask to enjoin further wrongful conduct by asking for an injunction. In the City of Rockford versus Express Scripts case, the plaintiffs urged that injunctive relief was required because Express Scripts was operating a specialty pharmacy in league with the drug company formerly known as Mallinckrodt, and that as a result, both private and governmental payers would pay more for drugs. Now, that case was later settled without an injunction, in large part because Mallinckrodt died in bankruptcy. Parties might seek an injunction for various reasons. Common scenarios include preventing irreparable harm that cannot be adequately remedied by money, for example, the seizure and planned sale of a home by a government agency. Land is considered to be unique, and that's why when you buy or enter into a contract for a house and someone reneges, you can get specific performance, which is a form of an injunction. Or stopping ongoing activities that violate rights, like intellectual property infringement, copyright infringement, or unconstitutional stop and frisk laws. Or maintaining the status quo during litigation to ensure fairness and justice. For example, ordering that a defendant not destroy documents that would normally be disposed of by a document retention policy. For a court to issue an injunction, several legal analyses must be conducted. Let's start with the doctrine of standing. The party seeking an injunction must have standing, meaning they must demonstrate a sufficient interest in the matter, a significant connection to the harm from the law or the action challenged. This ensures that courts only address actual disputes. The concept of standing broadly refers to a litigant's right to have a court rule upon the merits of particular claims for which he seeks judicial relief. The Supreme Court has held that a threshold procedural matter, a litigant must have standing in order to invoke the jurisdiction of a federal court, so that the court may exercise its remedial powers on his or her behalf. In general, for a party to establish Article 3 standing, he must allege and ultimately prove that he has a genuine stake in the outcome of the case because he has personally suffered or will imminently suffer 1. A concrete and particularized injury, 2. That is traceable to the allegedly unlawful actions of the opposing party, and 3. That is subject to being redressed or is redressable by a favorable judicial ruling. These requirements seek to ensure that the federal courts don't give essentially advisory opinions, that they're deciding actual cases and controversies. A court may not assume that someone has standing. It has to be pleaded and it has to be proved. After addressing standing, the court next must determine if all of the elements necessary for an injunction exist. The first, and likely the most important, is a likelihood of success on the merits. A likelihood of success on the merits is probably the most important of these elements. The party has to show that their underlying claim is likely to succeed. So, for example, if a federal agency were to pursue an action barred by statute, like maintaining a database of firearms purchases, the plaintiff would need to show that that action was unlawful under federal law, that there were no exceptions involved, and that he would be successful on that claim. And he has to do that at the beginning of the case, and he can do it without substantial evidence. The fact that he can do it without substantial evidence is one of the real risks of injunctive relief. And tellingly, it's widely regarded, as I said, as one of the most important factors. So that seems to be where a lot of the litigation really comes into play. The second factor is irreparable harm. There must be a showing that without the injunction, the party will suffer harm that can't be remedied by money. For example, if the government was going to come in and lay a cable across your yard without an easement, they were going to simply assert that they could lay this cable across your property, and they were going to dig up your yard, bury this cable, and then cover it back up. You have an action for trespass there, and you could get money damages from them doing that. And if the cable is properly buried, there's not really any risk of irreparable harm, and you can be made whole by essentially having the government pay for a permanent easement on your property so that this cable can go through it. I know this because my uncle owned a farm out in a little community called Smithton, Missouri. And Smithton, Missouri in the 1960s was right in the middle of the buildup of nuclear weapons. And they had missile silos all over the place. And the missile silos were connected by underground cables that ran underneath the property. So my uncle went out there when they were burying this cable across his property and took photographs of the government agents out there digging this trench and burying the cable. And about 2 days later, an FBI agent showed up at the door and said, "Hey, you can't do that." But essentially, the FBI showed up at my uncle's farm and said, "You can't take pictures of that because that's classified. Give me the film. Any images that are of you and your family at birthday parties we'll bring back to you, but those images, you can't have them." So essentially, they seized that property from my uncle, and he absolutely had a right to demand damages for them tearing up his property. But in the end, he decided that he really just didn't want to tangle that much with the FBI. So again, you have to show that the harm is not able to be remedied by money. And that is an absolute essential, irreparable harm in order to get an injunction. And this is also one of those areas where there tends to be a lot of friction, a lot of dispute in one of these injunctive actions. For example, in the case filed by the state of New York against the Trump administration in the Treasury Department, the plaintiffs there alleged that the risk that the new policy being implemented by Trump presented the disclosure of sensitive and confidential information and the heightened risk that systems in question will be more vulnerable than before to hacking. and the judge decided that that satisfied the irreparable harm standard. Now, what's interesting about that is that they made that showing by affidavit without a significant evidentiary showing and without the Trump administration being able to weigh in and rebut the claims because they got this injunction without notice to the federal government. The third thing that they have to show is they have to show balance of equities. This is where a court looks at the benefits and harms to both parties. So in the New York case, the benefit is that your confidential information is not going to be released, but the harm to the United States is that it can't go forward and audit and do the things necessary to see where all of the money is going. So the determination of which side would suffer more if the injunction were granted or benefit more if the injunction was granted, that was decided in the New York case by the judge issuing the temporary restraining order because he felt like the loss of billions of dollars a day was less important than the possibility that confidential information might be released. Similarly, in Trump versus Thompson, the district court found that the assertion of executive privilege would hamstring Congress in its legislative role. It balanced the equities in favor of full disclosure and transparency as opposed to protecting the issue of presidential privilege. And we'll discuss that case here in a little bit. And finally, the court has to consider whether issuing the injunction would be in the public's best interest. Now, many times, this is a situation between two private actors. In a case I'll talk about in a little bit, it was between a drug company and a city. These two actors, they were involved, and there was an injunction sought, and the court had to decide whether it was in the public's best interest to grant the injunction or not grant the injunction. This is usually the least weighty consideration in many cases, but should certainly be considered higher than it usually is. In a bankruptcy case, a bankrupt entity, for example, sought an injunction to prevent litigation against a co-defendant in opioid and other litigation from going forward against the co-defendant. And astoundingly, it was granted. And somehow, the idea that the drug company could stay in business for a few more days was more important than the public's interest in addressing the opioid crisis. Now, that was a bankruptcy judge. It was not an Article III judge. And so that issue never made it into the appellate system because of the really stupid way that bankruptcy appeals are handled. But nevertheless, it was granted without a significant balancing of the equities and without a consideration of the public's best interests. Now let's look at several notable cases that illustrate some of these principles. The first of these is Winter versus the Natural Resources Defense Council. It's a 2008 Supreme Court case. In that case, the Supreme Court emphasized the need for plaintiffs to demonstrate the likelihood of irreparable injury to obtain a preliminary injunction. The Navy in that case was conducting sonar training exercises, which the plaintiffs argued harmed marine life. The court ruled that national security interests outweighed the environmental concerns of a few dolphins, illustrating the balance of equities and the public interest factors. Anybody who wants to go look that up, it's 555 U.S. 7. Winter versus National Defense Resources Council. In eBay versus Merck Exchange, 547 U.S. 388, a 2006 case, the Supreme Court outlined the four-factor test for granting permanent injunctions in patent cases, emphasizing in that context that no one factor was dispositive. The case reinforced the necessity of proving irreparable harm and balancing the equities in intellectual property disputes. And then the third case, Trump versus Thompson. This is one I talked about earlier. In that case, the January 6th committee sought documents from the National Archives pertaining to the January 6th riot. Former President Trump asserted executive privilege over those documents. He said he would be irreparably harmed by the disclosure. President Biden, however, waived that privilege, and as a result, the court sided with Thompson, Benny Thompson, the congressman who brought the action, The court found that the former president's claim of irreparable injury was negated by President Biden's decision not to exert executive privilege and the historical precedent of presidents waiving privilege in the public interest. They pointed out that the harm, if any, was to the executive branch as a governmental entity and not to former President Trump at that time personally. Injunctions are a critical component of the legal system, and they offer protection and fairness where monetary remedies fall short. Understanding when and why they are issued helps us appreciate their role in maintaining justice. Now, there are two kinds of injunctions: permanent and temporary. Permanent injunctions are simply called injunctions, and the temporary variety are called temporary restraining orders, or TROs for short. And TROs are subject to different rules than our permanent injunctions, not so much in the factors, but in the procedure for obtaining them. Another thing about TROs that makes them different from permanent injunctions is that they can be sought without giving the other side of the controversy a turn at bat. Now, the rule says this about issuing without notice. The court may issue a temporary restraining order without written or oral notice to the adverse party or its attorney only if specific facts in an affidavit or a verified complaint clearly show that immediate and irreparable injury, loss, or damage will result to the movant, meaning the person bringing the action, before the adverse party can be heard in opposition. And B, the movant's attorney certifies in writing any efforts made to give notice and the reasons why it should not be required. So it works like this. You go in and with your pleading and you lay out the case for an injunction, and you provide your proof in the form of an affidavit. In the New York versus Trump case, the proof was done by a lawyer, and the lawyer said she had reviewed her file and she had evidence that supported standing and irreparable harm, and the U.S. never got a chance to rebut any of that information. And the federal judge at 1 o'clock in the morning issued the state's pre-written order of injunctive relief. Curiously, there was nothing in the proof that I saw that established that first factor, and likewise, nothing showed that it was justified for not giving notice. So it seemed to me that there was a little bit of the state of New York got a little bit of a more friendly review than it might have gotten elsewhere, but it was being reviewed in a court in New York and not in a federal court in the District of Columbia, which is probably where that injunction should have been brought. However, by getting the TRO, it put New York on the clock. There had to be a hearing on the request for temporary relief within 14 days. That was required by the rules. That hearing was held on Valentine's Day. In between, the U.S. filed a motion to vacate the order, and it raised several points. First, the court order is an impermissible intrusion into the separation of powers and Article 2 prerogatives. Now, as you're aware, Article 1 is the legislature, Article 2 is the executive branch, and Article 3 are the courts. So, generally speaking, all of those branches are co-equal. No one or the other trumps the others, no pun intended. So, when the court orders something in the executive branch, that can be an impermissible intrusion and a violation of separation of powers. Whether that's the case in this case will be determined probably later on by a different court. The court order's legitimacy was also called into question, and that's because the order's distinction between civil servants and political appointees had no legitimate basis, and the government was not aware of any example of a court ever trying to micromanage an agency in that way. The order hindered the Treasury Department's political leadership from performing their Article 2 duties of supervision, and that constitutes irreparable harm. And that's because any constitutional violation constitutes irreparable harm. And then political accountability was at issue. It limited the access of information to the political officers who were politically accountable for that information, and it was incompatible with the unitary structure of the executive branch. Now, Congress, Article 1, That's a group that has 538 people in it, all of them with legislative power. But the executive branch only has one, and that is the unitary executive, in this case, the President of the United States. And so as a result, it does affect the ability of that unitary executive, in this case, the president who appoints the secretary and the secretary who supervises the Treasury Department. It impedes their ability to do their jobs. That was the allegation, or the argument, I should say. And then one of the things that the state of New York said is, what are they complaining about? There's going to be a hearing on this injunction. It's only a temporary restraining order. And the United States came back and said the scheduled hearing doesn't negate the ongoing constitutional violation and irreparable harm. Finally, the plaintiffs will not suffer any harm from permitting the excluded officials from performing their duties, and the injunction is impermissibly overbroad, and it's not narrowly tailored to address the plaintiff's supposed harm. Another real issue there was that there was no opportunity in that case for pushback from the other side. If New York had filed an action for injunction and had it put on a what we call a rocket docket, where notice was served and the United States was given 3 days or 5 days or even 24 hours to provide a response, that would have developed a much better record, and it would have made appellate review much easier as well. Now, like most things that come up in the law, over 30 years, I've had my share of issues with injunctions. I'll give you 2 examples. The first is from a little town in Kansas called Neodesha. Now, in that situation, we had a client who died from necrotizing pneumonia. In fact, 70% of her lung was enveloped by this necrotizing pneumonia. And she had been seen at the hospital emergency room the night before she died. And the emergency room doctor essentially did nothing. He gave her a shot of Rocephin, which did nothing. He didn't listen to her lungs. He didn't draw any blood gases. He didn't do the kind of workup that you would normally do for someone who was having as much difficulty breathing as this woman was. So when she died the next morning, it's hard to believe that this is the case, but it's a small town. The medical examiner, or the coroner, was out of town, so the deputy coroner, who happened to be the doctor who'd seen her in the ER, came out to the house, looked at her, didn't examine her, just looked at her and said, "Well, she didn't die from anything I saw her for." So the doctor claimed the death was not related to his care or lack thereof. Well, we knew that he hadn't done a decent job in the emergency room, so we went to the hospital to get the medical records of the ER visit. And the hospital said, "Not so fast there, Slicky boy. You don't get the records because the doctor hasn't signed off on them yet." And if you've been in hospitals, you know that a lot of times doctors will try to cover their behind. I had a doctor that I had a great deal of respect for. He was a really good doctor who made a really bad decision and injected a patient with a drug that he shouldn't have given him. Now, it would have been perfectly fine if he'd put it into an IV drip and diluted it and given it that way, but instead he injected some into a vein directly, which caused immediate tachycardia, chest pain, and almost killed the poor guy. Luckily, it didn't kill him, but that's another story. Afterwards, instead of writing in the record that he had given this IV in the hand, what he wrote was that he had hung an isopril drip, which is not something that you really should be allowed to do. Go back and alter that afterwards, and he did it. So we do know that there is a potential for alteration of medical records. So we went to the local district judge, and he agreed that notice to the hospital would accelerate danger to them. It would accelerate the danger that they'd be altered. And he granted an injunction on an ex parte application. And that was proper because the judge knew, as did I, that it was very likely the doctor, who did no testing and did not even check blood oxygen levels, would rewrite the record to show that he did. We didn't give him that chance. So in that situation, I got the temporary restraining order, I got the records, and boy, did I honk off that doctor, not to mention the hospital administrator. So for me, it was a win both ways. Sorry, but you have to understand I come from that background and I know exactly how the cabbage gets cooked. So the next situation involved a case that I was working on called the United States ex rel Rigsby versus State Farm. Now, this was a case brought under the False Claims Act, and the allegation was that State Farm was pushing off on the federal flood control program a lot of the damages that were actually due to wind. We had two relators. They were Corey and Carrie Rigsby, two heroes in my view. And they were contracted through a service that provided adjusters, and that company was called EA Renfro and Company. Now, Rigsby's knew that State Farm was committing fraud, or at least that was their allegation. They believed that, and they needed evidence to show the government. And by the way, State Farm did wind up having to pay damages in that case to the government. The Rigsbys had full access to the State Farm computers through EA Renfro, and they downloaded the entirety of the State Farm's claims database from the Katrina disaster, which is where this all originated. And the records did show, at least based on the little bit of time that I got to spend with them, that State Farm was pushing off claims it should pay on the flood program. Now, the service employing the Rigsbys sought a temporary injunction to return all records and destroy electronic copies. The court served notice on the parties to appear for an injunction hearing, and the court only granted that injunction after notice and hearing. In other words, it didn't grant it on the ex parte basis where Renfro's lawyers came in with their hair on fire and said you had to stop this. So, to me, that was Judge William Acker in the Northern District of Alabama, and he was a great federal judge. If you read some of his opinions, he was a very learned man. He was a very good judge. I didn't agree with his issuing the injunction in that case, but I could understand where he felt like that was the right thing to do. Most courts don't issue TROs on an ex parte basis. Most courts are very suspicious of you when you come in and say, I need a temporary restraining order to stop this. They want the other side to be able to weigh in on why you think you need an injunction to prevent something. So most of the time, they'll set an emergency hearing on the docket, and they will get a later hearing for a full injunction if one is necessary. But the first hearing will occur usually within 24 to 48 hours, and that prevents people from running into court, like I said, with their hair on fire, claiming that the sky was falling, dogs and cats living together, all that stuff. And of course, that in most cases, the harm or the risk of harm is very much overblown. And that doesn't, I mean, that's the case no matter who's asking for the temporary injunction. So that is my experience with temporary restraining orders and with permanent injunctions. Now, to get a permanent injunction after you've gotten a temporary restraining order, or even after your temporary restraining order has been denied, you bring in your proof, you make your proof of all of the elements, and the judge has to decide whether to grant a permanent injunction, which essentially means it's not time limited. It doesn't apply only for 14 days the way a temporary restraining order does. It has to be it has to remain in effect indefinitely. Now, later on, you can ask a court to lift an injunction if there has been a change in circumstances, and a lot of times there's litigation in that respect too. Nobody should get too worked up over a temporary injunction because there is almost always an opportunity 5 or 10 days down the road to get rid of it or modify it or restrict it in some way. And that, I think, is probably the most important thing. Now, the idea that people working for the Department of Government Efficiency should be able to access individual records is, in my view, not a good thing. I don't think they should be able to find out how much, I was paid last year by Social Security. I don't think they should be able to find out how much a doctor is paid for Medicaid because it doesn't really relate to their role. That's just my belief. But should they be able to find out how much money was sent to the state of Alabama or the state of Florida, or how much we spent on foreign aid to Uzbekistan? Absolutely, they should be able to find that out because transparency is always in the public's best interest, so long as it does not violate somebody else's personal privacy. So that's what I have for you today. Thank you so much for being here. I hope you found this useful. Come on back and join me down here at the beach tomorrow. Thanks for watching my video. If you have a request for me to cover a topic, please send me an email to the address above, and in the subject line put video request. If you have comments, drop them in the comments down below. If you found the content worthy, please consider subscribing. Since I started doing this work, I have always asked listeners to consider doing just one kind thing every day to make somebody else smile or make their life better in some way. Please consider doing that. It makes the world a better place. Now, YouTube has some suggestions for other videos of mine you may find interesting.